Awesome. Okay, so we are here with a special meeting for the Human Rights Commission. We're just doing a meeting to go over some information for the reviews that you guys are going to be doing at your next regularly scheduled meeting, which is the second Thursday of November. It is all virtual. So we just wanted to go over the process. This is the first time maybe some of you have been exposed to it, or even if you have, just kind of a refresher on how the HRC typically does these. So we have a few slides, and Anna was gonna go over those. We'll both just chime in, but she's gonna lead us into just a few of those slides and let you know how we're like basically the standard review for reviews, just how the whole process is gonna run, and then we'll have some time for questions.
Okay. So hopefully this is going to work. Can you see the slides okay there?
Yes, thank you.
Okay. Okay, so we wanted to just kind of give you an orientation, what's going to happen, and what to expect. So the first thing we want to go through is just kind of a review of what the investigation process looks like when we receive a complaint. The OHR investigator is a neutral fact finder. We don't represent either party. We don't take sides in any matter that we look at. Both parties have the opportunity to present their position, evidence, witness, anything that they would like considered in the investigation. Then the investigator will make a determination based on the available facts and the law. Investigations include interviews with relevant witnesses, evidence review, and then we obtain the complainant's rebuttal to that. At the conclusion of the investigation, then OHR makes the determination whether there are reasonable grounds to show that a violation of the ordinance exists. And then we will prepare an investigative report, lays out everything that we looked at and what our findings are and how we arrived at that decision. And then we send that complaint or that report to the complainant for them to have the opportunity to review that. The complainant gets 10 business days to take a look at the report, and then if they decide that they would like to request a review of the Human Rights Commission, they can notify us of that, and then we will proceed with this process that we're going to talk about today. If a complainant does not make that request within 10 business days, then the determination becomes final at that point. Okay, so the standard that you will use to consider whether or not the complaint should be dismissed when they come for a review is an abuse of discretion. This is the standard. And the determination is an abuse of discretion only where it was unreasonable and clearly against the weight of the evidence. It is not enough for the complainant to simply repeat the facts that are stated in the investigative report or to restate information or arguments that were already considered. A complainant must show that either the investigation made significant factual errors or failed to include important information, that the conclusions in the report did not follow logically from the facts that were available, or that the conclusions were based on an incorrect interpretation of the law. Maggie, you had a question?
Yeah, if they come back with new information, where would that fall?
So that was, they needed to provide that during the process of the investigation. We go back to them multiple times and, anything else you want to include, anything like that.
Yeah, but just to make sure we're clear, like if they come back and say like, but there's this other piece of information that is not within the standard, like we can't consider.
Correct. That. They can't bring it in. Correct.
I also have a question. This report that's referenced here, I mean, I'm assuming so for example, for the two matters that we're planning to hear at the next meeting. So I'm assuming we're going to get in advance reports for each matter?
Yes, you are. And I'm going to go through what you'll receive. Yeah, we're going to cover all that. Yep. Alan, did you have a question? I just wanted to clarify, abuse of discretion, does that term mean that they don't think they're not agreeing with your conclusions, right, from the office based on the criteria you put forth on the previous slide?
Yeah, it's also like a way to differentiate from other standards. So for example, abuse of discretion as opposed to say a de novo review, where a de novo review, you guys will be looking at it with fresh eyes and not just whether we did not do one of these three things. You'd be kind of making your own determination. So that's not what you're doing here. Here you're looking at whether one of these three things happened here. And if they did, then you say, okay, you know, we're going to send it back. And Anna's just going to actually, I think it's on the next slide or something.
Yeah. So anytime someone requests a review, I mean, they didn't agree with what we ended up with, how we came out. I mean, that's why they're going to request this, but this is what they have to be able to show in order to show that the decision was an abuse of discretion.
Okay. And then one follow-up question, I'm sorry, but what you're laying out here on these slides, is this directly from the ordinance or is that some other document where this is laid out and been approved? Yeah.
This is from the ordinance. This is the standard that the ordinance lays out.
Okay. Thank you.
Sure. Okay. So what documents do you get? To your question, these are the documents that are shared with both the complainant when they make a request for a review and with the commission prior to your hearing. You get the letter or whatever document they gave us, an email, however they said to us, hey, you know, I want to have a review of this decision. A copy of the letter of determination and the final investigative report that we sent to them when we concluded the investigation, and then a copy of the original complaint of discrimination that they filed with us. Those are the things that are shared with you prior to the hearing and also with them. Okay. So what happens? How do you go through this process? The commission does go into a closed session for this process. It's not a public hearing, so it's not recorded. There are no members of the public or anybody who's not directly involved with the process that is admitted to the meeting. So you start your normal public meeting, call it to order. Then there's a process that you will use to go into say that you're going into a public hearing. I think, Jimmy, we've shared that language with you. We'll share it again. Then anyone who is not a part of the commission will be removed from if they're in the room or they're online or whatever, they'll be removed. And then you'll go into a closed session. We'll stop recording at that time. The commission staff will then present the case to you, go an overview of what the complaint was, our investigation and what we found. And then you can have the complainant's appearance. They can do it in person, they can do it virtually or by phone, they can do a written statement, whatever their preference is, or maybe provide a written statement ahead of time. They get 15 minutes. In certain occasions, the commission may grant them another 15 minutes if there's something really necessary to do that, but typically we don't recommend that you go beyond that. That helps to keep things kind of moving along. There are no witnesses presented. They may not bring any witness. They can bring a representative if they would like to do that, but they may not bring a witness. There's no new evidence presented, nothing that wasn't available or made available to the investigator during the investigation. The commission can ask the complainant questions about their statement or their concerns or additional information during this time. Then the commission will release the complainant from the hearing. They'll be removed from the meeting, and then the commission has the opportunity to do deliberation, a discussion about what they've heard, and vote on the determination. There's essentially two things: either to vote to dismiss the complaint as not an abuse of discretion, or you find that there was some issue there that was an abuse of discretion, you send it back to our office to do some further work on it. And then the commission will come out of closed session and either conduct further business or adjourn the meeting, whichever is appropriate. Maggie?
Yeah, so from similar processes I've worked on in the past, these are the hearings where inevitably someone brings up something that wasn't in the investigation that is relevant. Would you, just within the context we have, is the preference to say, like, recommendation for OHR to do further work for whatever new information, or to dismiss the complaint and ask the complainant to refile?
That one, because we can't, that's not part of the process. They're not permitted to bring, new things that they didn't share during the course of the investigation. So if they had something relevant that they wanted to refile and it was still timely and they could do so, then absolutely they should do
Okay,
that.
because just you're touching on one of the issues that my prior board kept coming up against is that timing. So like kind of the balancing the interests.
Yeah.
How has that worked in the past? Because I think it would be troublesome if it's like very relevant, and this is all theoretical, but like if it's very relevant, and it would be helpful for like just additional OHR work, is there the option to kind of say like, maybe we should go down this path for just a little, add in the additional information? So for example, previous boards, there are some of this, they'd be like one witness or something they couldn't get a hold of, and suddenly they're like, we can get you them now, or like they finally returned a phone call.
Yeah. I mean, I think in a case like that, that would be a departure from anything we've done ever in the past. We've never permitted that in the past. If it's something like a retaliation, like a new allegation related to something, that's different.
Yeah.
And we would say, well, you can bring the retaliation claim. That's a separate issue.
Absolutely. No, I'm talking about like new information on the claim in front of you.
Yeah, we have not ever.
I don't think we've ever. Go ahead.
Sorry. So just like to back this up a second, right? Because I do want to make sure that everything we're doing is consistent with the statute. And I'm looking right now at 31-7 enforcement proceedings initiated. I think what we're talking about here is in subsection B3, which is if the executive director determines that the complaint lacks reasonable grounds to believe a violation of this chapter has occurred, the director shall dismiss the complaint and advise the complainant in writing. Such dismissal becomes final, et cetera, et cetera, et cetera. And then it talks about the review procedure. And so I'm looking at that, and I guess the couple questions that I have is, number one, it talks about, upon request for review, the commission shall afford the complainant an opportunity to appear before the commission in person or by representative or by letter, as the complainant may desire, so that the complainant may show that the director's determination was an abuse of discretion. The commission may, in its discretion, request a response from the respondent. After such review, the commission may, in its discretion, dismiss such complaint if it finds that the executive director's determination was not an abuse of discretion. So I have a couple questions about all of this. Number one, I know what abuse of discretion means in the federal litigation context, right? There's different standards of review on appeal. There's de novo, which means you look at everything fresh. There's abuse of discretion, which is basically the clear air standard, and different courts articulate it different ways, but it has a very clear legal meaning. I guess my first question is there anywhere in the Arlington Code where Arlington actually defines what it means by abuse of discretion? Because I don't want to just assume it's the same thing that it means in federal court. So that's my first question. My second question is, as I read this language, it kind of seems it's interesting, right? It says the commission may, in its discretion, and normally when I read legal documents, in its discretion means you have wide discretion, request a response from the respondent, great. And then after such review, the commission may, in its discretion, dismiss such complaint if it finds that the executive director's determination was not an abuse of discretion, which almost reads as if we have discretion to allow the complaint to proceed or to have the investigation continue, even if we think it was not an abuse of discretion. So it's very strangely worded there. So that's my second question. And then the third question is, in terms of this being a record review, and again, I'm very familiar with, from the government context, a record review means you can only look at what was the record before. And usually this comes up of, there's an agency, it looks at the record, it goes up on appeal. When you're looking, you can only look at the record that was before, whoever reviewed it in the first instance. I'm just not seeing anywhere in this human rights statute anything that talks about that, about this being a record review, about it being limited to what was below and no new evidence can come in. So my third question is, where is the statutory basis for that limitation?
I think that comes from I don't know if that's coming from the rules of procedure. As far as the abuse of discretion, I'd have to look at the code again. Some of this information is coming from this document called Rules of Procedure, which we can share with you guys. And where that came from, we actually don't know. That's been with the office and the way the decisions have been done the reviews have been done for the last, I don't know, over however many decades. To specifically answer your question on if there was something that came up, even though that hasn't come to us before, that was new, specifically regarding an allegation that you were now considering for review, you could read at abuse of discretion to say, okay, we want to send it back. But I think what you'd have to note is we're not finding an abuse of discretion here because this is new information, you can't use that to be an abuse of discretion. So if you note that and say, we're not finding an abuse of discretion, but, you know, like to Maggie's point, if it's a timeliness issue or something, right? And you can't, or it's an urgent type thing, you could say, but given the fact that this new information has just come to light, you know, and it appears that it could be material and relevant, we would, you know, ask the Office of Human Rights to look into this further, noting it's not an abuse of discretion that we're finding. I suppose you could do something like that. And as far as if they file a new complaint, I imagine it would be similar to, I think this is in the ordinance, but similar to kind of like in the federal sector, where if you know or you should have known or have reasonably known something to have occurred, you could probably get an extension of time in terms of timing tolling, right? Like when you can file. So that, I know that came up earlier. But the definition itself, I'm not sure if that's in there, Jimmy, or if that's in the rules of procedure, but we can look at that and get back to you.
It'd be helpful for us to, number one, have those rules of procedure that you're referring to. To the extent we don't know where those came from or originated, to the extent we could figure that out, so we can figure out whether these are actually binding or valid, or whether they're just some rules somebody wrote and they've carried down for years and nobody knows why, but they're not actually based in law. That would be very good to know as well. And then, yeah, I guess my third question on just broadly is how quickly can we all get the investigative reports?
So you can get that first of next week. We'll be sending all of that out. You know, we notify the complainants when their hearing is, and give them all of those documents. The rules of procedure is something also that is shared with you, so we'll be sending you that document as well. But we can get you those first of next week.
That's perfect. And then, oh, go ahead.
Sorry, logistics question. How will you share those? Is this going to be like a password protected file?
No, not typically. No, we send them to you by email, but we can do it.
Yeah, we can password protect it.
We can.
The rules of procedure, I don't care if that's protected or not, but if in terms of the investigative
file,
the
report,
is, you know,
we can.
Yeah.
Want that
password
encrypted?
Yeah, separate email with the password.
Yes.
Very good. And then I guess this is a broader question for the commission, because, you know, according to the statute, in the discretion of the chair, which is me, the commission that hears this can either be the full commission or it can be a panel of 3 commission members. I'm inclined to say it's the full commission, unless there are commission members who would like to tell me you do not want to be involved with this. So I just want to open that up. Hearing nobody expressing a view that you... Oh, Dylan?
Oh, I was just going to say I agree that I think it should be the full commission.
Okay, so hearing nobody express a view that they do not want to be involved in this, then this will be the full commission hearing these complaints. Very good. And therefore, let's make sure that all that stuff gets sent to all of the commissioners at the same time on Monday. Alan?
Yeah. So on a related note, do quorum rules apply, given that you can restrict the number of people who hear this?
It's a good question. You mean in terms of, like, you know, voting on what to do, right?
Yeah, exactly.
My assumption would be that they do, but Gurjit, Anna?
I would think that it would be, unless you had a special meeting where you only had 3 members hearing it. Then if you're having a regular meeting, then you have to have your regular quorum.
Yeah, that would be my assumption as well, which is also part of why I want to make sure that we, seeing as we're going to have the whole commission hear this and not limit it to 3 commission members, we just got to make sure that we have full attendance so that we don't have a quorum issue when we're deciding on this.
Yeah, if you guys think about it and you realize there's a chance you may not make it, maybe let Jimmy know so he can tell us before we send those out, because then we'll only send them out to the folks that are hearing it, you know?
And
like if you decide you're only going to do 3.
The date, is it can you repeat?
It's the 13th.
13th.
November 13th. And that one is scheduled to be one of your virtual meetings. You can certainly do that, or you know, if you prefer to do it another way, just need to let us know so that we can make sure we have a space.
So if anyone would think, well, yeah.
Is there
go ahead.
The complainants, were they given the option to meet in person or virtually?
They are given that option. If the commission is meeting in person and they want to come in person, they're given an option. They don't. It's up to them.
Do we know if did they tell us what? Yeah.
Yeah.
They didn't. I would suspect both of them would want to be virtual. One of them lives in Maryland.
Okay.
The other one, I think
So what we can do is we could reach out to them again just to see if they've decided, and if we hear anything, we can let you know. But that may change. I don't know if that's going to change if anything for anyone here in terms of whether or not they can make it and how many can attend. Because what if, I guess what you're getting at is, suppose they both write back and are like, hey, we want to come in person, right? Then we can change it, let's say by next Friday to in person. But then will that change any of the ability for you all to come in?
Right. Let's do this. Let's let the complainants know that we have a regularly scheduled virtual meeting on the 13th, and that is when we're planning to hear this. If they express a desire to be heard in person, then let's reassess. We will probably have to schedule it for a different time, because I think a lot of people are counting on the 13th being virtual. So if they want to be heard in person, then we'll just need to kick their appeal hearing for a different date.
Okay.
Should we take a moment now to see who can actually make it if it were shifted for the same date to an in-person meeting?
I won't be able to make it. So.
Okay.
Anyone else? Everyone? Okay. So it's basically, yeah. Okay.
Okay. So just let us know as soon as possible if they come back and say we absolutely want to be in person, and then we'll pick a different date.
Okay.
I'll find out. Let's see if we can find out first next week. Okay. So that was it. I think we've done questions. Any other questions about this process, or what to expect, or how we can help you be prepared?
And Jimmy, I think you have all the info I sent to you a few weeks ago, right? With the language and all of that. So you should have all that.
You sent me something in terms of the going to closed section info. But I don't think I think
all the other stuff, whatever you asked for, I sent it about, I think 2.5-3 weeks ago. So just let me know. Next week I'm out for most of the week. So I'm here. Yeah. So I can email. I'll be checking email on Monday at least. So I can try to see if there's anything you need resent. But I mean, typically they run pretty smoothly. I think, just a lot of complainants naturally want to be heard. I think the biggest thing that sometimes it's hard that, to keep in mind is sometimes many complainants are sympathetic, and we do sympathize. I know Anna and I talk about this often. We so sympathize. It's just based on the elements, which you'll hear from us about, when we weave the elements into the explanation when you go into closed hearing from us about the case. Why we found what we found. We'll start out with, this is the allegation, and to show this, you have to show X, Y, and Z, and here's where it was shown or not shown. So it's just important to keep that in mind for folks that haven't done it before. Like it's very tough to stay neutral, but you have to, even when you're sympathetic. So and you do
one
have
question, just because many of us haven't seen your case files before for this. Is there the chance of any information that staff might have that is not going to be in the report? Because I just don't want to be in a situation where the complainant says something that is not in what we have, but you guys know, I just want to know how inclusive the report we're getting is.
I mean, the report's going to contain all the relevant material. So if something comes up from the complainant, and complainant says, well, I as far as this goes, they didn't consider Y, but I told them it was Z, right? We would be able to explain why we didn't consider Z. Like, oh, well, I sent them a list of 5 witnesses. This is not like, how in the federal government, you get the ROIs or reports of investigation, and they have all the exhibits and it's not like that.
Transcripts from interviews. Okay. So
none of that. You're getting basically the report, you're getting the documents that Anna laid out earlier. And then in terms of questions that come up regarding other information, we would know then we'd be able to explain why we did or did not consider it or what that was about.
Also, I mean, I think there's a lot of questions we could ask right now, totally in the abstract and hypothetical. I think it might be helpful since we have some time.
Once you get the report.
Once everyone has a chance to see the report on Monday, digest it, and then if there's follow-up questions commission members have, let's have a chance to ask those.
Okay.
Anything else? Anything else that folks want to voice? Any questions for the last minute we have? If not, then I will plan to send out an email to everybody, just, talking about this meeting, what's outstanding. We'll get the report and the procedures on Monday. And then after a couple days, I think I'll send out another email. But obviously, if you have questions before that, feel free to send me an email. But otherwise, I will send out saying, hey, anybody have any follow-up questions having reviewed the report? Should we have another special meeting ahead of this hearing? And make sure that everyone has a chance to get all questions answered before we actually have these hearings. All right, if that sounds good and there's nothing else, then I guess a special meeting. So I move to adjourn.
Okay.
Second.
Happy Friday, all. Take care.
Thanks all.
Thanks, everybody. Have a good weekend.
Bye, everyone.
Thanks.